All right, welcome everybody. Hopefully you can hear us okay and see the screen as we'll be presenting a PowerPoint presentation that will complement our guest speaker today. If you are having any issues, technical issues, please again submit those requests at webinars@avenuinsights.com, or you can give us a call at 571-323-1253, and we'd be happy to help. First, thank you so much for joining us here today, as we are extremely excited to present on franchise fee revenue and specifically how local governments can maximize this revenue stream in your particular jurisdiction. We'll begin our discussion today by providing clarity around franchise fee revenue and why this is important to local governments. And this will be followed by specific challenges in the industry and how you should consider ways to increase and maintain that compliance. We'll be discussing, the presentation today will last around 40 to 45 minutes, give or take, and we'll have a short 10 to 15 minute question and answer period directly following that presentation. You can submit those questions throughout the presentation today in the chat feature located here in WebEx, as I can see many of you have already found that. Or you can also submit them directly via email, webinars@avenu, A-V-E-N-U, insights, INSIGHTS.com. So first, just wanted to introduce to you myself and our presenter today. My name is Brennan Middleton, Marketing Manager here at Avenu Insights and Analytics, and I'll be your host today. I'll also be responsible for fielding those questions or comments or feedback that you may have throughout the presentation and in the coming days. So feel free to let us know if you have any questions, comments, or concerns, and we'd be happy to get back to you as soon as possible. Next, I'd like to introduce to you our speaker and presenter today, Jonathan Gerth, Avenu Insights and Analytics, President of Tax and Audit Services. Graduate of the Thomas Goods Jones School of Law, Jonathan brings over a decade of experience across diverse industries, including professional auditor, accountant, and attorney. As a former Internal Revenue Service agent and tax attorney, his expertise spans across areas of auditing and regulatory compliance, assessment and collection practices, and tax litigation. Most recently recognized by the Birmingham Business Journal as a top 40 under 40 professional for 2018, Jonathan directly oversees Avenu's Audit Division, a nationwide team of certified examiners and accountants. Jonathan draws upon these unique skill sets and experiences to help local governments of all sizes better maximize existing revenue streams while also providing insight to future compliance strategies. All right. So who is Avenu Insights and Analytics? While partnering with over 3,000 government agencies nationwide, we aim and work with state and local officials to deliver software and services that boost revenue, optimize operations, and in all, deepen community trust. Our solutions for administration and revenue enhancement enable jurisdictions to provide a truly digital government that meets expectations of the citizens, the employees, and the elected officials. So for the agenda, as we previously mentioned, we'll provide additional clarity around franchise fees in general and why they matter to local governments, but also we'll discuss the challenges and trends that local governments are facing in all categories of utilities, including telecommunications, natural gas, electricity, and water and solid waste. Following that brief outline, we'll provide specific calculations that illuminate current compliance levels in your jurisdiction, followed by some recommendations and steps taken to help maximize that franchise fee compliance. Following the presentation day, we'll have a short question and answer period like I already mentioned, so submit those to the chat feature or webinars@avenuinsights.com. And just before we get started, I want to make aware that we'll provide a customized special offer at the end today that will provide specific feedback and analysis on your specific jurisdiction's current state and the potential enhancement of franchise fee revenue. So that's definitely something that you want to hang around and you don't want to miss that. So without further ado, I'd like to welcome to the floor Jonathan Gerth.
Well, thank you, Brennan, for that flattering introduction. And without further ado, we will get started. We will start with the basics here. So franchise fees, what are they? Well, first and foremost, it's important to recognize that franchise fees are not taxes. This is something that's been held all the way up to the United States Supreme Court. They are rather a form of rent, meaning the price paid or for the use of the public rights-of-way within a city or a county. They are negotiated or contractual as a property right for which the utility compensates the governmental entity for use of their rights-of-ways, as opposed to a tax, which is generally defined as a forced charge or imposition, which operates whether we like it or not, and is not subject to or dependent upon negotiation or the will of contract. So faced with this distinction, federal courts throughout the country have set forth a three-part test that has been applied in various ways throughout the country to test whether something constitutes a tax or a fee. And the first question that's generally posed in that regard is what entity imposes the charge? If it's a charge imposed by the legislature of the state, it typically indicates that it is in the nature of a tax. However, if it's an agency, such as a public utility commission or a local government that institutes the charge, it's more indicative of a fee. Second, and more importantly, is what population is subject to the charge. If it's a levy that is widespread and then placed upon the general population as a whole, it's going to be more indicative of a tax. However, if it's levied only on a narrow class of persons or a single entity, such as a utility company or a type of utility, then it's going to be more indicative that it is a fee. So the final question that's typically asked is what purposes are served by the use of the monies that are derived or obtained from the charge by the government. If it goes to the general revenue fund, that's typically more indicative of a tax. However, if it's designated for a special fund reserved for defraying regulatory costs related to the service, it's also more indicative of a fee. Now, the importance of that distinction is vital for various reasons in that in some instances, governments are required to comply with certain prerequisites before the passage of a tax. For those of you in the state of California, you're very familiar with Proposition 218 and other states which require a vote of the public for the passage of a tax. In some other instances, there's a requisite approval by the state legislature before a tax can be levied at a local level. There's also other administrative hurdles such as compliance with taxpayer rights or statutory taxpayer bills of rights. The distinction also comes into play when with regard to the Internet Tax Freedom Act, which prohibits the taxation of revenues or access to the Internet or any revenues derived therefrom, which under a tax you cannot do. However, under a fee you can. So this distinction can be very important, which will be further addressed later.
So franchise fees represent roughly 5 to 7% of budgets, right? And up to 10% of a government's revenue at times. Jonathan, it seems like that's a pretty significant source of income for many of these local governments. Can we shift and elaborate a little bit more on the types of municipalities that are impacted by this, and further specifically how they're impacted by this?
Of course, yes, and of course, challenges with compliance with franchise fees. As you can see, the significance of the amount of revenue that they can generate for a municipality can be determinative of whether or not a local budget is operating in the red or the black, and that can sometimes be based upon compliance. And it's applicable nationwide in essentially every municipality and county throughout the country, because having utilities is pretty much essential to the establishment and existence of all communities and for the betterment of all communities in most instances, and that's across the board for all types of utilities. So some of the challenges that you face in maintaining compliance in these industries are, if you're operating under a local franchise and you have, aspects within that agreement that are not favorable to the local jurisdiction because they're often drafted by the utility companies. The typical terms of these agreements are 15 to 25 years, so you can be stuck with them for a long time if you have a bad definition of gross receipts or a lack of local audit authority. and particularly under a state-issued certificate of franchise, oftentimes those are issued in perpetuity. So it's very important to monitor the terms and compliance with your local agreements, whether it be a state-issued franchise or a locally one. So two of the main aspects that you want to look at is how broad and expansive and inclusive is your definition of gross receipts, and what types of revenues are generated by each franchisee that can be encompassed within that definition. Now, we've just taken a few examples here in certain states where we operate heavily to address a few of the state-specific concerns and issues that come up in these types of audits. For instance, for the state of California, many of the gas and electric franchisers are subject to a formula established by the Broughton Act of, I believe, 1937, which is essentially a pretty complex formula that can be subject to various errors and misallocations. So it's something that's always necessary to monitor. Revenue allocation formulas for other purposes as well, such as commissions and other types of things, can be subject to error and compliance issues. Also, very important is compliance with, on the telecom side, with public, educational, and governmental fees that are used to fund public access channels and support those features. Within the state of Oklahoma, we've seen widespread issues with compliance with, or the omission of, miscellaneous non-recurring revenue charges such as late fees, connection fees, disconnection fees. And you have to keep in mind that the utility companies are very much akin to banks, and that they derive up to 10% or a substantial portion of their revenues, not from the sale of their service, but from these non-recurring charges. So another issue that we've encountered on a widespread level is in the state of Texas with the telecom industry, whereby although you have a state-issued franchise, and state guidelines that are applicable to all the same utilities, there's a complete lack of uniformity as to how they're being applied by each utility. And the PUC in Texas has not been willing to provide much guidance in regard to that. So that can result in an omission of up to 10% of the revenues from your local franchise that you should be generating and should be going into your local government.
So furthermore, with regard to compliance challenges, as we all know, all utility companies are subject to being non-compliant. So next, we're going to outline the difference in compliance challenges and provide specifics on all areas of coverage throughout the entire utility industry. We'll provide specific ways that each of these industries will attempt to minimize the tax liabilities across telecommunications, natural gas, electricity, and water and solid waste.
Well, thank you, Brennan. And yes, of course, we'll start with the big one, which is telecommunications, because this industry is one of the ones that is most ripe for non-compliance based upon their aggressive tactics, tax compliance procedures, and their efforts to minimize the taxation of their industry. So it also encompasses so many different types of services, such as cable, internet, telephone, cellular, in some instances. So it's very important to monitor compliance with this industry, because things such as charges for equipment rental, miscellaneous fees, early termination fees, if they're contractually based, are oftentimes omitted from revenues that are subjected to the franchise, whether it be a utility tax that's typically a license tax, or whether it's a franchise fee. There's also a substantial amount of omission of advertising revenues, which most people overlook, and home shopping commissions that are derived by the utility companies or the telecommunication companies that are supposed to be encompassed in revenues subject to the franchise, and how these entities are actually apportioning that revenue that's either derived statewide or nationally. How they're apportioning that to your local government can be a serious compliance issue and can omit a lot of revenue that causes leakage in franchise fees. The fee-on-fee issue is one that has been long-lived and is basically applicable in all the types of utilities. And that's when companies are treating the franchise fee, whether it be a license fee or a franchise fee, that's actually levied directly on the utility provider. They treat it sometimes as an indirect tax by which they merely act as a conduit through which they pass it along to the customer, and then they just remit it directly to the locality without, in most cases, that is prohibited under the definition of gross receipts, and if they do that, they are required to include that fee as part of gross revenues. So another issue that we've seen a lot of is this issue, this industry, the technological advances that occur in this industry happen so fast and are ever-changing, and we often see where these utility companies will, use terminology and new technologies and advancements therein to use that as a method by which they can exclude certain services from the franchise fee just based upon the obsolete language that's within it, because the new type of service is not necessarily encompassed within that language because it's somewhat outdated or it's advanced. Also in commercial operations where, the utility company is providing telecom to a commercial building that's going to encompass thousands of access lines and internet access, fax machines, telephone lines, cable, all these types of things. And oftentimes they're run through what's called a PBX type public branch exchange or a Centrex type service, and the utility company will take every advantage of that in trying to say that because they run one T1 line into a commercial building, they're only subject to one access line fee and not the hundreds or thousands and different types of counts that are subject to that. Next, we'll touch upon the natural gas industry, which is somewhat less complex, but still oftentimes subject to a large degree of noncompliance. So some of the issues that we encounter on these types of audits are, of course, as with all, the omission of revenue for service charges, miscellaneous fees, repairs, disconnect fees, late charges, things of that nature. And another issue that often comes up here is that in most cities and counties, you're going to have one the largest provider that's actually going to be the one that builds the infrastructure for your city, and it's going to have the pipelines that are running beneath the ground and connecting customers to the natural gas service. Now, oftentimes there are prohibitions against monopolies from operating within a city, which essentially requires the natural gas entity that has laid the infrastructure to allow other entities to transport gas through their system to customers that have registered with them. And there's oftentimes a volumetric rate or a revenue-based fee that they charge to those other entities for access to their pipelines and their infrastructure. And that can be sometimes a complex calculation under a volumetric rate and is often subject to noncompliance, and we see a lot of revenues get omitted based upon that. Of course, the fee-on-fee issue, just like we discussed in telecom, is always an issue here as well, and that's dependent on your local laws and what's the language of your local agreement, whether it be a state-issued agreement or otherwise. There's also different issues with revenue classification and how they're determining that and how they're subjecting that to your definition of gross receipts. And in some cases, there's a lack of regulatory bodies that actually govern these types of this industry. For instance, I like to use the example in Texas, where the Texas Public Utility Commission covers all utility companies except for natural gas, which is still and has since 1913 been governed by the Railroad Commission of Texas, which is its sole function. So that can add to issues of noncompliance. Next, we'll touch upon the electricity industry, which is oftentimes a huge revenue base for local franchise agreements and such. Although it's somewhat simpler, these entities are just as aggressive in their tax compliance and methodologies as are the others. The omission of various types of revenue, such as miscellaneous service charges and other non-recurring fees, are oftentimes an issue on these audits. There's also issues with sometimes the larger entities will be selling electricity that they generate to some of the smaller entities, whether it be a cooperative or otherwise, And, you know, under most tax types, wholesale sales are exempt, but under a lot of franchises, these wholesale sales and the revenues derived from them, which can be very substantial, are often not exempt under a franchise agreement. So there can just be confusion in that area as well. And, of course, the fee-on-fee issue and treating it as an indirect tax levied on the consumer as opposed to what is actually a direct tax or fee levied upon the utility provider. That's pretty much a universal issue in all of these, of course. Now, the water and solid waste industry is one that oftentimes gets less attention because in many cases it's city-owned or city-provided. The city will have a water authority or a solid waste authority that is run by the city. So they don't often want to monitor compliance with it or conduct audits on it because it tends to be a conflict. But in instances where, you know, you're outsourcing your water provider, you know, there can be issues that come, I'm sure oftentimes people have seen, where you have a water meter in front of your house and, you know, the readings and the fees that you're subjected to are typically, you know, monitored manually. You'll see somebody driving by your house and looking at your water meter to determine how much you use. So they don't have the smart meters and other technologies that, say, electrical companies will have for monitoring use. That can lead to a substantial omission of customers within the community that should be coded within your community, or it can lead to oftentimes an understatement or sometimes even an overstatement of revenue for customers that were previously on septic systems or just based upon human error. The solid waste industry is one that is absolutely ripe with noncompliance. You know, especially if you're outsourcing it. They do everything within their power to minimize their tax liability, and oftentimes there is a large omission of revenues. And, of course, the fee-on-fee issue is always in existence there as well. For those of you that have a landfill within your community, that is oftentimes a huge revenue generator for your local community, and that's usually based upon a host fee or a tipping fee that's based upon the tonnage that is received by each customer that comes to drop off solid waste at the landfill. And they, you know, oftentimes these agreements encompass some sort of, you know, reciprocal increase or incremental increase in that tipping fee if they charge certain customers different rates, which they often do to entice them to come and use their landfill as opposed to, you know, the landfill in the county next to you. So oftentimes when they charge a higher rate for different levels of hazardous waste, they don't often increase or reciprocate that with the amount that they remit to the jurisdictions, which can result in a huge omission of revenue and can deprive you of monies that you are due.
Excellent, Jonathan. Wow, awesome. Let's take just a quick moment to catch your breath. But next, let's move into, you know, some of the current trends that are happening in the marketplace today, and further expand on, you know, some of the pending litigation that I'm sure many of the folks on the line today are aware of that could have a dramatic impact, you know, in various ways across the country. And secondly, we're going to talk a little bit about the shift in the market where content streaming over the internet has become, you know, extremely more relevant in recent years. So let's dive into those two areas real quick.
Sure, Brady, you bring up great points there, and I'd like to address them. Yes, in the telecommunications industry, historically, telecom entities derived the majority of their revenue from cable subscribers and landline telephones and bundled packages. There has been a dramatic shift over the years, especially recently, with people pulling the plug, so to speak, on their cable access and rather go into a streaming service, in which has led to the revenues have essentially flipped. And the largest revenue producer for most telecom companies nowadays is broadband. And if you have a statewide communication service tax, you're not able to subject those revenues to a tax because of the Internet Tax Freedom Act. So there's been a lot of litigation in certain states over whether or not, you know, the taxation of Internet access and, you know, fees charged for modem the rental of modems that connect you to the internet are actually subject to a statewide communication service tax, whether they're bundled or whether they're individually provided. Some of the litigation that we've seen on the state-specific level is, just in some cases, state Supreme Courts, particularly in Kentucky, have recently struck down statewide communication services taxes, which are essentially prohibit local governments from entering into local franchise agreements with utility providers because it deprives them of a vested constitutional state right to contract with these types of entities. And that recently happened in Kentucky. There's also a statewide tax in Florida that prohibits municipalities and counties from actually contracting or entering into locally issued franchise agreements with the telecom industry, and thus prohibits them from taxing any broadband services. Missouri's had issues as well because they have a statewide utility tax, and whether or not it's been the subject of a lot of litigation. On a national level, we've started to see a lot of lobbying efforts based upon the shift to broadband nationwide, whereby the telecommunications companies, who have a very strong lobby in every state, are making efforts and trying to get bills passed to minimize the amount of fees that local governments are allowed to charge them on the laying of broadband cable and the use of the rights of ways within the city. The same thing happens with cell towers, antennas, and not to mention we've also seen where a lot of mergers and acquisitions are constantly occurring in this industry. Just recently, Charter Communications purchased and acquired Time Warner Telecom and Bright House, an effort that Comcast tried to do several years ago that was blocked by the FCC, being based upon a potential monopoly whereby we almost became the United States of Comcast. And but it was allowed by Charter, which made them, that shift has made them from being the predominant provider in one state, which was their home state of Missouri. They are now the largest provider in 8 states based upon that acquisition. So
Jonathan,
how do you know if you're, oh, sorry.
That's okay. Yeah, I was just going to say, so Jonathan, many are probably, wondering at this point, how do they know if their utilities are compliant with franchise fee remittances? And let's discuss current compliance levels and how to increase and maintain their franchise fee compliance, and what is the best way to determine current compliance levels?
Well, a quick test that is often used to determine whether or not you have issues is just by, a quick formula that you can use to plug in your locality's numbers based upon the number of households that are in your locality, multiplying that by the average utility bill for a specific utility, and that can usually be determined by city or governmental employees that are subscribers to those utilities, and then multiplying that by 12 to get what your average annual gross receipts derived by that utility company should be, multiplying that by the franchise fee rate, which should come pretty close, or at least within the vicinity of what you're receiving annually from that utility provider. So that's a quick test that you can perform to somewhat determine whether or not you may or may not have issues of underreporting. Now, of course, the best way to test for compliance is to conduct an audit this is something that Avenu does nationwide, and we've conducted hundreds of these throughout the entire country, and they can oftentimes be very eye-opening as to what's being omitted. This is just a general process by which we undergo in conducting these audits, which we make essentially seamless for the local governments because we handle everything in this regard. So, for the sake of time, we're going to kind of skip over some of this because this is a standard audit procedure. They're going to put up a strong audit defense. They're going to require us to enter into a non-disclosure agreement, which we've audited most of these entities before and have a prearranged agreement with most. So that's something that we handle for you altogether. So it's important to recognize that having compliance in your jurisdiction is more than just about revenue, too. It's also, an issue with leveling the playing field and providing an equal level of competition to provide the best rates and the most benefit to the citizens of your community. So what you want to do in that regard is make sure that you're auditing these utilities on an often enough basis, which in most instances these utilities are subject to a 3 to up to 5 to 6 year audit period. So it's not something that you have to do all together that often, but it's important to do it as often as possible because, you know, what we see is that there's a lack of uniformity in these entities. Just because we correct something in one city doesn't mean they correct everything nationwide. And when there's an acquisition, sometimes the tax policies change. If they change softwares, sometimes that changes their level of compliance. So you want to keep a uniform, fair enforcement to eliminate competitive advantages for certain utilities. You know, also the long-term nature of the utility company and their investment within your community is something that you want to make sure you handle these governmental affairs personnel and these types of audits with a very high level of professionalism, because it's a long-term relationship that you have with your utility company, because once they get in your community and they lay an infrastructure within there, it's very difficult to get them out. So you know, we have a very vast multi-jurisdictional view and understanding of how these issues are trending nationwide, and we're able to apply what we've learned in other states and what we've seen in certain entities. We're able to apply that to your local community based upon our experience. So another aspect that we have is our legal enforcement and our ability to provide that for you, which essentially, you know, allows you to stand your ground on the audit and doesn't allow them to overwhelm you with these entities have vast resources, huge legal departments, large governmental affairs divisions and regulatory affairs divisions that are typically comprised mostly of attorneys, accountants, and other resources that they can use to combat audit efforts. So what you're up against here is that many cities, counties, and special districts don't know about what issues to look for on these audits. You know, if you haven't conducted them on a frequent basis, oftentimes you're not up to speed with advancements in technology and other issues that typically arise in these types of audits and what types of revenues should be subjected to the franchise. Also, many don't have the internal resources that are necessary to conduct these types of audits because they do require a certain level of expertise and knowledge of the industry, and sometimes often involve legal battles, not necessarily in the courtroom, but at the end of an audit, you know, whether it's just letter-based or whether it's, you know, over the phone. So, you know, you may not have the legal power or the knowledge or the experience in this industry to face off with the efforts that they're going to make to combat the audit results. So that's where we definitely come in very handy in that regard. So it's important to emphasize that, you know, you should not let your municipality or county forego franchise fees. They can be a substantial amount of revenue for your local community and can go towards bettering the community altogether and providing better services. Avenu is here to help in that regard. We have over 35 years combined experience in auditing these types of entities. We have extensive relations with national providers because we have contacts with these providers. We've audited them throughout the country. They recognize us as being a reputable and very professional firm, and they know how formidable we are. We're not going to lay down and die for them. So it's very important to have that type of relationship with them, and that's one of the things that we're able to bring to the table. Also, because of our level of experience in this, we're very familiar with the types of issues that are going to be encountered and how to resolve those issues and what types of revenues generally get omitted and how we are able to force those into the definition of your gross receipts. So, you know, you have to, going into these types of audits, you have to know the potential issues to look for and what types of revenues are typically generated by these utility providers in order to make sure that you're identifying all the revenue that you're due.
Wow, really great, Jonathan. Thanks for that informative, you know, massive amounts of content in all of those sections. We'd like to move into the question and answer period here. I do know that we have tons of questions that are coming in, not only via chat, but also the email submission right now. So we're going to get to as many as we can here in the next 10, 15 minutes. Again, you can submit those in the chat and also at webinars@avenueinsights.com. So Jonathan, the first question that came in was, my city shares zip codes with another city. How can I know whether the utilities are including the right customers in their fee payments?
Well, that is often a very common issue that we encounter on audits. If you're a jurisdiction that is landlocked and butted up directly against another city or locality, and you share zip codes, which are often the basis under which their softwares code customers, you can have issues as to whether or not the customers are coded properly. We perform a geocoding aspect as part of every franchise audit to ensure that all customers are properly coded for your jurisdiction. And in many cases, if we performed services for you in the past, we may already have your jurisdiction geocoded based upon proprietary softwares that we have. So we may be able to do that for you in a seamless way. Or if you have a water authority or a city-based utility that already has all the addresses within your city, we can use that to cross-reference with their customer listings, and especially along those borders and where you share zip codes. That is often a very ripe issue for noncompliance.
Fantastic. So next one is more of a process-based question, Jonathan. It says, can you describe the process of how Avenu specifically deals with utility companies not wanting to cooperate? For instance, if they disagree with an audit result, like what does Avenu do as far as process is concerned?
Well, typically, like I said, these issues don't often end up in the courtroom because they're long-term relationships that you have with your utility company, and they don't want to go to court either. That's oftentimes the last resort. We've seen very, very few in the hundreds of audits that we've conducted nationwide. We've maybe seen one go to court. So we are typically able to provide the legal expertise, which will typically, if a utility entity disagrees with the results of an audit, they're going to do so by letter, and they're going to protest the audit results and make their argument in writing. And we handle that for you. We will apply the laws and make the arguments for you and respond to them directly in writing. And in most instances, we know the types of arguments that they're going to make because they do so on a universal level in most instances, and we know how to defeat them. So oftentimes we are able to bring these matters to a close, and we consider that as part of our auditing service. That's not something we do in addition to the audit. That is something that is encompassed within the audit service as a whole.
Great. I did want to quickly interject here and remind everyone about the special offer we'll be having here in just a second as we get through the Q&A period. So hang tight with us, stay tuned, and we'll provide some of those analysis that we'll be providing for you, for all the attendees. So Jonathan, next comes to us. It says, what happens when a utility says they can't provide requested information because of federal privacy rules? You kind of touched on that already.
Well, we've seen that a lot in the telecommunications industry, which is governed in a heavy way by the Telecommunications Act of 1937, and there's a lot of federal laws that protect customer information, and we've seen that as an audit defense mechanism whereby a utility company is going to say, well, we cannot provide that data because it's customer or personally identifiable information under the federal laws. And we're well aware of those federal laws, and there is a clear exemption within them for local audits of franchises and things of that nature. So we don't require those types of laws are typically, put in place to protect usage and content and what they're looking at, purchases, things of that nature, personal information that is not relevant to the audit. All we're the fact is to whether or not somebody's a customer and how much revenue the utility company generated from them are not protected under those laws, and we know how to make that argument go away very expediently.
Great. So next one comes out of Oklahoma, Jonathan. This one says, have you ever heard of an electric company that states they cannot refund underpaid franchise fees due to regulatory compliance, meaning this, the compliance states that they must collect the uncollected franchise fees from their customers?
We have seen that in some instances whereby the utility company says that, well, if we undercollected the revenue to begin with, we can't go back and charge the customer because one, they may no longer be a customer. Two, they may no longer live here. That's typically protected within the language of the franchise agreement. Oklahoma allows locally issued franchise agreements, and if the error is based upon an undercollection or not subjecting certain revenues by the utility company, they will try to use that as a defense mechanism. They'll say, well, we're going to start charging customers an additional fee to recoup this amount. And there are administrative rulings from the Oklahoma Public Utility Commission that have prohibited that, that can. So we have encountered that issue, and they try to use that against the city to say that, well, we're going to tell everybody that, we're charging the customers, your citizens and voters, more because you conducted an audit. Well, they're not legally allowed to do that. If they make an error in collection, then it's not strictly a pass-through. This is a tax that's levied on the utility company, so it's not a consumer tax. So that is, that's an issue that we've encountered and are very adept at handling.
Great. So next one, and possibly our last one here from a time management perspective. This one comes out of California specifically, Jonathan. It says, can you touch upon any area of California legislation relating to the shift to broadband and the impact on the telecom franchise fees in California? So no kind of specific there.
I have not seen that in California. The primary area of litigation ongoing right now is within the state of Texas, whereby the state legislature in this session actually passed a bill, and the city attorneys of McAllen and the city of Dallas city attorney, which is a client of ours, are forging a court battle against that legislation. So I'm sure the lobbying efforts are ongoing in California, especially given the length of their legislative session, which essentially runs almost throughout the entire year. I don't know if anything's in the pipeline right now. We do monitor legislation, and we have a governmental affairs division in the state of California, and we are heavily involved in Sacramento through our government relations personnel. And we monitor those issues, but that has not been one that has come up as of yet. However, it would not surprise me if it's in the pipeline and could come this year, given I don't think their legislative session ends until around August or so. So we could see something, but we have not yet.
Awesome. Well, great. So from a time perspective, we're gonna wrap up here today with our special offer. But again, submit any questions that we didn't get to today. We will respond to those independently. And if you do have any comments or concerns or questions after the presentation, please feel free to submit those. But to jump right into our next phase here, Jonathan, the special offer that we mentioned at the beginning and during our question and answer period. Avenu, we want to offer a complimentary assessment of your specific jurisdiction's compliance level with, potential revenue to be recovered through, a partnership with someone like Avenu. So we're looking to complete these customized, and we request that you send an inquiry if this is something that you're interested in or want further information about. We ask that you please, shoot us a quick note at webinars@avenuinsights.com, or actually give us a call directly at 571-323-1253, and we'd be happy to chat with you further on some of the tactics or the logistics that we go about to complete that assessment, and we will work with you directly on getting that back to you. And lastly, we just want to say thank you for joining us here today. Many of you, most all of you have stayed to the end here, and we appreciate your attention. Thank you for taking the time out of your schedules to join us today. Hopefully, some value was provided, and also again, providing inquiries, questions, comments, feedback. We'd love to hear from you. Webinars at avenueinsights.com or give us a call at 571-323-1253. Hope everyone has a wonderful day.